Welcome to Case Files, the human factor. We are going to unpack and explore human behavior. And human behavior is fascinating. We're going to look at trauma, victimology, and I'm going to use all of my expertise over the last 25 years to really give you the gift of understanding human behavior and the fascination we've got with psychopathology, crime, victimology, criminal justice, mental health, forensics and statutory cases. And with that, I will, on my own and with the assistance of some of my guest speakers, really give you insight in what the human factor means in our lives and our daily existence. Welcome to the human factor. We are going to discuss today the best interests of children and the voice of children, and to look at safeguarding and risk factors. I've got Claudio Bollo in the studio with me from South Africa, and he is a lawyer there that works in this field. So welcome, Claudio.
Thank you. Good morning, good afternoon.
So we're going to jump in. And we are going to look specifically today about the importance of safeguarding people that face litigation, that are in mediation, and that is involved in family dispute resolution. And we are also going to look at the importance of just children in proceedings and in mediation, and the concept of including children and their voice into proceedings, that they are being heard. Now, people would think that that has always been the case, but fortunately started to shift. But at times, in a lot of mediation processes and in the courts, children weren't really heard, and lip service was really sort of given to safeguarding and risk factors. And it sounds strange, but that was really the fact. But things have now moved forward where there's a lot of focus on risks, how to evaluate risks, and also in mediation proceedings. And then also when you look at sort of hearing the child and what the child is saying, that is now being included, and there's really a focus on giving a voice to children. So Claudio, if you think about just in matters and where you've been involved in, can you just give us an idea of how important it is to hear what children have to say, where they are being affected and where they are involved in these kind of matters, family law matters, or where they've been placed in risk? We have to hear them. What is your views on that?
I guess the world is a very different place today than what it was even 10 years ago, or say 50 years ago when I was a child. In those days, you used to hear the phrase coined, children should be seen but not heard. And today you have jurisdictions in which it's compulsory for parents to say, when they sign a settlement agreement in a divorce matter, for example, we've spoken to the children. They too have been made aware of what we are agreeing to. They're agreeable to it. And obviously this is age specific, or it's determined by age, of course. A child of 1 or 2 years old is not going to have that kind of voice, and perhaps sometimes you need an expert to unpack what children are saying. One doesn't necessarily listen to every single word or every single whim or intention of a child, or of an adult for that matter. Sometimes experts get involved. Lawyers maybe normally follow suit. We listen to experts such as yourself telling us, this is what I see is in the best interest of the child. That's what I see should be done in order to make this practical. The arrangements one has, for example, for contact. The modern day and age is involves a lot of technology. Obviously, children today are exposed to a lot more knowledge than even 10, 15 years ago. So perhaps they're more aware of what's happening. I think children, in a way, have become more resilient or knowledgeable about the fact that families do split up. Issues happen within families, and obviously it's important to protect as well, and make sure that whatever people do disclose during, for example, a mediation process or a screening process or an assessment process remains confidential, private, family related, and not something that goes out there on social media or in newspapers and gets reported on just because it sounds interesting for people to read or to know about.
And I think it's that balance of, we have to protect children, absolutely, at all costs and safeguard them, but they also have to be heard. But we obviously have to look at sort of keeping their identities, if it is, for example, in court proceedings, and even in mediation, we have to always look at what is good for the child from a privacy point of view. Is their voice or what they say going to put them in risk? So we have to consider that as well. And then obviously we have to look at their human right to be heard and their freedom of expression as well. So for me, what is very important and quite critical in all of these things is to look at all of our human rights. What is the human right to actually be able to speak up and to tell our story and to have voice? So we say everyone should have voice, but I don't think really, if we look at a lot of matters and if we look at mediation proceedings, not everyone and not all children are even included in mediation, parenting mediations. So this is now the time that I think we have to all reconsider our own sort of perspectives and perhaps our own training to look at the legislation, to look at the sort of the new thought processes of how do we really fully include the child and give them their right as a human to express their thoughts, to express their stories, to tell us about their lives. I'm quite a big believer in every person knows sort of their story, what they've gone through and what they have lived through. And if we do not give children, we give parents that opportunity, to say what has happened. They give their versions, their narratives, sometimes in affidavit form, or if it's in mediation or family dispute resolution, they may perhaps provide a summary of their experiences. But it is not always found that we give the child that opportunity to tell us their story. So for me, what is important is that we always have to think, where does the child's story fit into these processes? And we have to give them the opportunity through trained practitioners. So if that is a trained professional like a mediator or a family dispute resolutions practitioner or a psychologist or social worker or lawyer, but they have to be trained to be mindful that they can really capture the child's story and understand the child's life. And I do think we are still a little bit on the back foot with that on training, that people don't know how to sit with children and really interview them properly or capture their stories. What do you feel on that topic of interviewing children? Do you think people and practitioners are fully equipped to sit with children and hear them and capture their voice?
I think an interesting aspect, and I didn't touch on it earlier, is that many jurisdictions are introducing or have introduced the issue of appointing a legal practitioner to independently represent the child or children. So a child or children will have their own lawyer, as it were, even paid for by the parents or sometimes even by the state, if the parents can't, to make sure that even legally speaking, it's one thing to hear the child's voice, it's another to have someone arguing to say, well, now that we've heard the child or that experts have interviewed the child and made reports and said, this is what I see happening, this is now legally speaking what now must be done according to this particular practitioner in order to safeguard that child's rights and best enforce them going forward. So that's an interesting aspect. I think that, of course, you get lawyers and lawyers, you get experts and experts the world over, and it's always very important to make sure that those people that are involved in family disputes are sensitive to the relevant issues, are sensitive to the risks, are sensitive to the needs of children in particular, because they are ultimately the defenseless or innocent parties in any family dispute are the children generally. So they are deserving, I would guess, or I would say more deserving of assistance, of legal assistance, of expert assistance, of sensitivity in the whole process.
And I think it brings us to the point of children are vulnerable, and we need to treat them as a vulnerable population group. And in saying that, that is why we need really experienced practitioners, experienced, if it's in a mediation context, mediators that can work with children. If it has gone to court, we obviously need experienced practitioners there to be able to deal with the vulnerabilities of children. So that for me is very important. And it's not everyone that can sit with a child. I think professionals need to look at themselves as well and need to know, are they really fully equipped to be able to sit with a child, that the child has got a safe place where they can tell their story and can really sort of speak to what they need, that we can capture their needs, that we can convey their needs, and to look absolutely at what is in their best interest. Because that is often in these kind of cases missing, is that, you know, there's such a lot of side issues that people forget sometimes, or it gets lost in translation, what is really in the best interest of the child. Now, obviously, all of these processes are set up to actually look at what is in the best interest of the child. That's why we mediate. That's why there's family dispute resolution sort of processes. That is why there is courts that looks at the best interest of the child. But I have seen over and over again, and a lot of these processes, the intention is good, but it does not translate into reality where we actually look and serve the best interest of the child. So very important, I think, systemically for professionals, but for the whole system as a whole, including the family members, the parents, the children, siblings, but we have to look at what is good for the child and nearly capture that and be able to, at the end of the process, really serve the child's needs and wishes and look at what is really good for them and what is in their best interest. So it's easier said than done, but I do think that is still a process, and it needs well-trained practitioners to really sit with children and facilitate that process.
I think that judges who insist on mediation in those countries where mediation is not compulsory, or countries that have introduced compulsory mediation, are on the right track on this issue, because it's very easy to get involved in the monetary issues that sometimes bedevil these types of family disputes, and to forget about the fact that the human factor and the children in particular are much more important to look at it and to make sure that there's a lasting arrangement going forward, that they can still feel, I've had a normal family, or I've had a good family where my parents have assisted me in growing up and becoming who I am one day, 10, 15, 20 years hence.
Clyde, and I think that is a valuable point, because I think all of us that have been working in this field, some people have, lost some heart in doing what they are doing. And I do think that is problematic for families that go through challenging times, because you can't just, you become a number, or you become sort of part of the system, or you become sort of, it's just for fees. And what is important to remember is that we are actually dealing with humans. It's real people with real lives, and the decisions that are being made and the facilitation processes are exceptionally important for that person. So for the mediator or the lawyer or the practitioner sitting on the other side, it's just another person that they are seeing. But for that person, it's that, it's an hour or two of their day that changes their life forever. And we must not forget, we cannot, as practitioners, ever forget that hour or two that you are facilitating, or you're sitting and capturing that story and narrative and looking at their interest and what they really want or their needs, that affects their whole life most likely going forward. It's a snowball effect. So there's a lot of responsibility on the practitioners to really do a good job, to really take on the responsibility of dealing with humans and their lives and the impact that you have on facilitating these processes with these families.
What we're seeing in the legal fraternity is that there's a lot more specialization in family law, I think, than perhaps in the past. And it's not just an offshoot of litigation. So yes, if you're going to represent a mother or a father in their financial aspects, of course, that's very important. One wants to make sure that a mother is looked after going forward if she's not the breadwinner, in the modern day and age where many women earn more than men, vice versa. But at the end of the day, yes, that's important. But the most important thing is that the children are looked after in the process. And very often people forget that, and they'll end up just litigating with each other, and so do the lawyers. They think, well, I'm a litigator. But ultimately, you're actually not. You're dealing with family ultimately, and not just money. In fact, if you don't deal with the family aspect, the money side of it actually sometimes harms everything even more.
Absolutely. Claudia, I do think, perhaps a last point on just the children's matters is, I think people need to be open. And as you say, we've shifted through time, and we're living in a different time. Years ago, and many sort of, perhaps still sometimes now, people are not open to hear children. There's still sort of a narrative where children should not be heard. I've seen that in some of the matters that I've been involved. It's nearly if children are put on the sideline and the parents decides what is best, or even in cases where, in sort of mediation or in sort of these court battles, there's other sort of people that decide what is best for children. And I do feel there is a huge limitation if we do not understand what the child's world looks like, what is really good for them, and we hear it first from the child. We need to sort of create sort of a system and an environment where everything else takes second place and is secondary to what is the sort of what comes from the child directly. What are they telling us about their life? What can work for the child? What is practical? What is the fears and anxieties of children? What do they feel uncomfortable with? We need to really understand the child's world and then bring that into the process, not the other way around. The child does not come secondary to these processes. They are the most important, and they have to take center stage in any kind of proceeding where they are involved. So where a child is involved in a proceeding, it is very important that we hear from that child. Now, often, as what you've mentioned earlier, children are in different developmental phases of their lives. So it's not that easy to sit with smaller children. And I think for a lot of professionals, they've got an idea that they can only sit with a 6-year-old or a 3-year-old or a 12-year-old. So we need to also sort of see what kind of professionals and the specific training those professionals should have that sits with younger children as well, because younger children also have views. If you look at the first 7 years of a child's life and the importance of that formative years, if you are well trained as a practitioner, you are able to sit with a child that age in their first formative years, up to 7, 8 years of age, and really understand what their life looks like. But I don't think all practitioners feel comfortable to sit with children that are of a younger age. So very important that everyone knows what their comfort zone is when speaking to children, and to really work with children on an age-appropriate level, that we can understand where is that child and meeting that child at that point of their age, and that we can translate and explain that information into the system, into the process, that people can understand, okay, the child is this age, this is what they're going through, this is their needs, this is their wishes, that we can meet the child where the child is at. We should not expect that a child should meet the process or fit into a process because that is other people that thinks that they know best. Yes, parents and adults do know, they can contribute and they can explain what they think is good for children, but it is still important that we meet the child where the child is at, because the child's information can really highlight what is in the best interest of the child, what is really best for the child, and how this child is going to look, how their life is going to look like. So very important that we sit with the child and really understand the child's world.
And quite interestingly, I've been practicing for over 30 years, but 3 or 4 years ago was the first time that I saw a judge in court say to the practitioners, I'd like to see these children. Can you bring them to my chambers tomorrow morning at 9 o'clock? I want to talk to them. And that was quite interesting. And it was a judge who's steeped in family law, has obviously, before being a judge, practiced in that field for many years, had deep thinking about what one must do to give a child an opportunity to be heard. And sometimes what better manner than for the judge, in this case was herself, to listen to the child or the children and say, okay, I've now also heard them. I'm not just being told what they feel, what they think, how traumatized they may or may not be, how they see things going forward, how they can interact with the father or with the mother. And often in these cases, one or other parent are maligned by the other parent, and sometimes one doesn't know where do these children actually stand, because even experts sometimes are partisan in nature in the sense that they're appointed by one or the other party. So maybe psychologically or as human beings, we say, well, let me see how I can make this work for my client or for the person who appointed me. It's not that easy sometimes to be objective as one party's legal practitioner or expert or is not someone highly or fully independent in a matter. And it was just interesting that the judge did that, and it is happening more and more. And there has in the past been a reluctance. I've argued matters where I've said, let's hear from this expert orally, let's let the person testify. And because the matter's all been on paper, judges have been reluctant. Or let's hear from the children. Judges sometimes are reluctant. And maybe it's because we're steeped in what we've always done historically. But if we come back to the future and look at the type of age we live in, and where children know all kinds of things that children didn't know or get exposed to not even 10 or 15 years ago, then one says, well, let's hear from these children, because they can speak for themselves and can give a better impression to someone who's impartial, perhaps, than someone who maybe is only listening for certain things to be said.
And I do think, Claudio, it should be explorative in nature, because when children are involved, we have to explore. We can't be rigid, because it's multifactorial, it's multifaceted, and there's a lot of things to consider when children are involved. I, interestingly enough, also, have been in a matter and where that is exactly what happened. And the judge sort of sat with the children, and it was small children, and interviewed sort of the children. And I really, it is such, it's admirable, and it's good to see that is happening currently, because you hear it from the child. There's no contamination. You sit with the child and you hear and you open. And for the judge to hear directly from the child in some of these cases are incredibly powerful. So I do think that is the way forwards. Interestingly enough, I spoke to a judge the other day, and they said that it very seldom happens. That's definitely the way to go. But it really, and in all of his years, he has not done that. So there is really a lot of work still to be done, where everyone feels comfortable enough and empowered enough to do that and feel equipped and skilled to do that. But once again, as what I've said, it is definitely time where we make it more about the children. Because the reality is, if you think about family law cases, there's hours and hours that people sit in court and they speak about the children. Are the children really being heard? Are they really being invited into the process? I want to be bold enough to say, no, I don't think that they are always really present and fully emerge into it. And obviously they have to be safeguarded. They can't go and sit there and they can't be overly involved, but they need to be there in spirit. They need to be heard, and we need to know what they really say. I think that also brings us to the aspect of, there's such a lot of contamination in these processes. Even in mediation processes, before it goes to court, and that's obviously there to prevent people to go to court. But there's interviews, and then the interviewer or the mediator or whoever is doing it, they capture, but they don't fully capture what the child is saying. So it's like playing broken telephone. So you hear, but then you convey the message, and it's not even the right or correct message. We have to be very careful that we don't sort of play broken telephone with children's narratives. So it needs to be the accurate version. It needs to be truthful. The interviewer can't bring their own biases or own perceptions or own ideas into the process. We need to really put forward what the child is telling us, that we can understand fully what to do with that information.
An interesting aspect that I've seen in practice in a few matters that I'm currently involved in, and it's obviously never really desirable that children testify in court cases, but sometimes in cases where children have either been emotionally or physically abused in some way by one or other or both parents, it is important to hear what they say, even in a court context. And what's happened with technology is it's now normal that you can do things virtually. So, for example, you'll have children being asked to testify in a matter, and you won't have both parents watching over them in a court of law where they're under serious pressure and don't want to say what may or may not have happened or how they may or may not feel. And I think in the mediation space or in the assessment space, that's probably even more apt, because there perhaps you can easily interview children by themselves without the parents present if you believe that that's the way to go. But court cases have now, with the use of technology, been able to have people in the same building, but not in the same room, for example, and children not being in the same room as the parent who might have harmed them, or maybe where they can be influenced by the other parent to say certain things or not to say certain things. And this is important in arriving at the truth, because ultimately, as we'll all appreciate, one has to get to the truth in order to then decide what's in the child's best interest. If you don't get to the truth first, you'll never be able to do that.
The truth is important in proceedings. The truth is important, and people need to be more honest. And, children are, I've interviewed lots and lots of children, and children are inherently honest. If you ask them and you don't lead them and you don't guide them, and you create a platform of neutrality, they will tell you, and they will tell you what has happened in their life. You just need to create a safe space, and they will tell the story. But unfortunately, in a lot of these matters, there is not that opportunity where a safe space is created for children to just fully and honestly sit and tell what has happened to them and what they want and what their needs are.
That's correct. And I guess the legal space is the worst space for children to spontaneously just come out and say things, especially when it involves their parents, especially when it involves tough, unpleasant things that might have happened, even if it's just screaming and shouting and people not agreeing with each other. Very difficult. And I guess that's where experts like you come in. But I think the mediation process also comes in, because if it's too adversarial, then lawyers are just representing their clients and fighting each other to show who's the more intelligent, who's the more aggressive lawyer. And that really isn't what the family law space needs to be, especially in the interest of children.
Absolutely. And as what you've earlier said, in some jurisdictions, mediation is mandatory. You have to do it. In some countries, you don't. So you can just sort of approach the court. In Australia, you have to go through a mediation process before you can enter the court system. but we are still seeing that people are just sort of, they use mediation just to get to court. So they're not very serious about mediation. They just see it as a hurdle. Let's get over this, and then we go to court because we actually want to fight, or we want to sort of go into litigation because they're highly litigious. But if people start to really take mediation seriously, the power of mediation and what it can do to take people out of the court system, to resolve things amicably, and to still sort of to look at their relationships and try and hold on to good relationships. That is definitely the long-term mental health and wellness people can hold on to. The litigious fatigue that people develop when they go into litigation, the years that they lose in their life, all of those things can be prevented if people really work well in mediation and they bring their A game and they listen to the children when there's child-inclusive mediation, and they are open-minded to find peaceful resolutions. That's definitely where we should shift towards, that we can try and become less litigious, and that we can actually protect families and protect children from difficult and challenging court proceedings that is not always in the best interest of families. Obviously, in exceptional circumstances where there's a need for litigation and court proceedings, that needs to happen. But if we can prevent it and we can solve matters in mediation and family dispute resolution practices, that is definitely what needs to be occurring more, and I would say on a worldwide platform, not just in jurisdictions where mediation is mandatory.
So in South Africa, you can say in your papers when you issue them that you object to mediation because A, B, C, D. And sometimes you write there because the parties have tried and it's just impossible for them to reach agreement and all of that. But I think that's probably a wrong concept. One shouldn't allow parties to say, I object to it. It should actually be enforced. And where judges then come in is if it's not obligatory, a judge can decide anything in the best interest of a child, including you will go off and mediate and come back to me when a skilled mediator has said to me what's going on. So I think that's something important. You get jurisdictions in the world where there's a compulsory 3-year period of separation before parents can get divorced. Part of the reason for that is to say, well, it's a family fabric. We're trying to protect it. We're not going to make divorce that easy, and we're going to make the parties interact as much as we can in that period. If you then mix that up with, and I'm not saying we should in all jurisdictions go to a situation where if one wants to get divorced, it's a long process or a costly process, but let's make it necessary for the parties to interact, because if parents are completely at loggerhead, then what chance do the children have? They have no chance.
And I think it's such a complicated concept because in Australia there is, it has to be sort of a 1 year and 1 day separation, and then sort of you can divorce. But, you know, and that there's good reasoning, as what you've now said as well, is look at a restorative approach and perspective on families to keep families together. There's always another side to the story. So there's always two sides that we have to consider. And because there's also in some of these matters that should be restorative, it also ignites sort of more family violence where there's more coercive control, and one person wants to exit and the other person then use that sort of system to keep the person in a coercive controlling relationship. So as what we know, and we know very well, it's a very complex space. And we need to look at proactive solutions of, obviously, how can we keep families together, but how can we also respect when people make the decision to leave a marriage. And then obviously a huge factor to consider is family violence, gender-based violence, abuse in marriages, abuse of children, and how do we look at that as our first considering factor of safeguarding people that are in those kind of family dynamics. So that is also very important to look at, for example, in a mediation process. And that is, mediation is possible where there's shuttle mediation, or if there's risk factors that needs to be considered, we need to look at evaluating that risk factors with risk assessment tools to make sure if people enter into mediation or if they go into a family court dispute, how do we protect the vulnerable people? How do we protect victims, and not just pay lip service, but to really have methods and safeguarding in place, principles in place to protect vulnerable people that goes through these processes. And I'll, for example, use an example here is, if we look at really implementing safeguarding methods, you can't sit in an office, for example, and there's a domestic violence dispute and someone that has offended someone, but now you expect these clients to sit in the same office or sit in the same mediation room. You don't take into consideration any risk factors, or you bring a child that might have been abused into sort of a mediation space where they now have to go and say what they've experienced in mediation, where they've been placed at risk. Today, still, we see that is happening. It is absolutely bizarre. As what I often say, my favorite word is, I'm flabbergasted that is still happening, that mediators are still allowing it, that the courts are still expecting that, where offenders and victims need to sit in the same courtroom. We have to be smarter than that, but we're not. So we really have to start thinking, how do we fully sort of understand what people go through that has gone through domestic violence, that have gone through family violence, and what precautions and safeguarding mechanisms do we have to put in place in mediation, in the courtroom, to really protect people that have gone through difficult things. But I say again, that is not always happening. I see it every day, and it is important that we as practitioners and mediators, solicitors, lawyers, all of the mental health practitioners and the court system understand we are re-victimizing these families, and we need to think forwards to address this critical need when it comes to the family law space.
Well, it all depends what country and what world we want to be. So South Africa is a country that's got a very interesting and sometimes difficult, but sometimes also brilliant history. Yet, and gender-based violence is a big catchword today, and we're focusing on it today. But I never learned that phrase at school 30 years ago, or however long, probably a bit longer, or at university. And we weren't taught how to spot or look for gender-based violence when we did family law. So these are all things that the world needs to bring itself to understand as best we can, as quickly as we can, because society and problems can get away from you if you don't control things. And a whole generation can have huge problems and issues when it grows up if you don't look after that generation. And I think going forward, and I think, thank goodness, most jurisdictions are focusing on making sure there's no gender-based violence that's tolerated, making sure that children are the most protected people in society, and so on.
And I think that is where we really have to look through a humanistic perspective and a lens, and we have to meet people where they are at. We have to safeguard them through these processes. We have to really consider risk. We have to look at what is in everyone's best interest, but specifically people that are vulnerable, children that are vulnerable, or people that have been violated that is vulnerable. And we must make sure that all proceedings is safe and in the best interest of all parties, that people can feel that they are protected and that they can go forward without any form of risk or secondary victimization, because that is highly problematic in these processes that we see. I'm doing a conference later this month on filicide, and it is problematic how many family murders there are, how many females are being murdered, in high conflict custody disputes, how many children have been victimized. And obviously there is sort of, it's a lower statistic of male murders, but we have to start thinking, what are people going through and how can we protect them through these processes with thinking what is realistic, what is appropriate, and what is safe. And I do feel that mediation is a platform where we can really offer people to feel that they are being safeguarded if we appropriately mediate. And obviously, if it goes to court, then we need to look at what is in the best interest of all parties to make sure people are safe and protected.
Well, I think that from a legal perspective, what we need to focus on is to ensure that we don't simply make things an adversarial debate the whole time.
Yes.
It's easy to listen to a client who says, no, he must never see the children, or she must not have a chance to phone the children, or whatever the case is. And you then fighting to champion that instead of perhaps engaging with the client to say, why do you want to do this? Why would you like a parent to be arrested because maybe they did something which could arguably be wrong, but why do you want them arrested? They're the father, they're the mother, etc. And I think lawyers play a very important role, but also we need to be guided by people such as yourself who really know the emotional, psychological, and the other human aspects a lot better than we do, and can guide us to say, do not push your client to do ABC. Do not force us into an adversarial system where the children can't handle this and not going to cope, etc., etc. And if you're just chasing dollars or rands or whatever your currency may be, then this will be just ignored.
And
but I don't think we should do that going forward.
Absolutely. And I think we do not need adversarial, because that is problematic for the general well-being of all families. And that is why people often separate as well, is because of conflict and high conflict. And we don't want to push that into a further realm of adversarial processes. So we need to look at what is good and proper and calm and peaceful resolutions. Perhaps just the last point to pick up on that you brought up is technology. I do think that plays a big part of how we can really safeguard people, as what you've mentioned, is in courtrooms where children can now be on screens and they can give evidence. The same in mediation that is online, where people actually don't have to go through those pressures of sitting in the same room, or children can Zoom in. Kids are so amazing with technology these days, and it can really be used to the benefit, where you actually don't have to go through that stressful process to go into a room or into a building or quite a clinical space often, or a courtroom, that we can actually sort of have them in the comfort of their homes where they feel safe and secure. And should that not be our thought process at all times, is to keep people as safe and as comfortable as what they can be. So I do think technology, as what it goes on in life, we can really use it to our benefit in the family law space, or in a space where children are involved and vulnerable, to see how we can use that to their benefit.
Fully agree. Even lawyers' offices need to be non-intimidating, nice places to go.
Yes.
Similar to when you go to the dentist, you're nervous. Things need to calm you down. The people involved need to calm you down, including the lawyer.
Yes.
So yes, I think the technological aspect is a very big game changer in this particular issue, especially where children are involved and where you do want them to be calm and relaxed and not under pressure.
And I think future focus in our wish list would be, is to really make the whole system more child friendly, that people feel that we are there really for the children, and how to sort of make sure that they are feeling safe and secure, and that their life can go on, and that we can meet their needs without further adversarial and scary processes that unfold. And even for the parents or for the families, that they don't have to sit in spaces and with people that make them feel uncomfortable or that is intimidating in nature. So very important that we look at that sort of with a future focused perspective of how do a court system and how does all of these systems meet the needs of the people and meet the needs of the humans, that they feel that they are protected and that they are not being intimidated by the systems that unfortunately a lot of people still feel intimidated by the processes that are supposed to be there to help them, but is harming them and not helping them. So thank you, Claudia, for that. I really appreciate your input on just the best interests of the child, hearing the children, looking at risks, safeguarding. All of these things tie into sort of the human factor in legal proceedings, and very important that we just speak about it openly, that people can understand that the process is not there and it's not intended to intimidate them or to harm them, but to help them. So thank you for your input today.
Thank you very much.